Hello, this is UCL Uncovering Politics, and this week we ask, do we have a human right against discrimination? Hello, my name is Emily McTernan, and welcome to UCL Uncovering Politics, the podcast of the School of Public Policy and Department of Political Science at University College London. Today we'll be doing a deep dive into the philosophical underpinnings of human rights. Our topic in particular is the right against discrimination. Discriminating against people on the basis of things like their sexual orientation, you might think, obviously wrongs them. But do we have a human right against such discrimination? And is there something distinctively wrong about being discriminated against? Some theorists of human rights don't think so. But our guest today disagrees and offers us a different, perhaps better, way to think about the grounding of human rights. So today I'm delighted to be joined by Dr. Saladin Meckled-Garcia, Associate Professor in Human Rights and Political Philosophy here in the Department of Political Science. Welcome back to UCL Uncovering Politics, Saladin.
Thank you. I'm glad to be here, and I look forward to this discussion.
So we're going to start with a really big question or basic question about the work, which is something like, why are we talking about human rights and discrimination together? Why don't we just think about discrimination in the way that we usually do about particular laws against particular kinds of discrimination?
Good. That's a really top question, and I think that really helps me to get into the subject. So the reason to ask about human rights is connected, first of all, to the reason why we might ask about moral rights against discrimination, which is that it's very easy to point and explain why discrimination as a general practice is problematic or wrongful or something that we might socially want to get rid of, engineer out, create norms against. And indeed, we have legal systems now in operation that militate against various forms of discriminatory activity. But something that's left out from merely talking about it as a social ill, a general social ill, is the individual experience of it, or not experience, but the individual being targeted by it. In an important way, the wrong of discrimination isn't just a social ill, but is a personal sufferance, a personal wrong. In a way, discrimination, when it's wrong, is personal, right? It is against a person discriminated. And there's a problem in explaining why that's the case or how that's the case, because we can point to lots of social ills, but any one case of discrimination might not have those features that make it a social ill, right? So a person may face an example of discrimination. Take an example like from one of the papers I've been working on, Vilma. So Vilma is a Latina woman, and she works in a software company. The example is based on something that happened to a group of Latina women working for Uber 10 years ago or so, and they won a settlement of £10 million. So this is a subject matter that matters, right? And let's say that in this example, like Vilma is going for a works bonus. It's not a particularly big bonus. It's 1% of pay. And the person deciding on whether she's performed well enough to get the performance bonus decides not to give her the bonus, but secretly does so because that person has a discriminatory attitude towards Latinas because he doesn't like Hispanic people. She doesn't know about it. She doesn't know the causes of it. As far as she's concerned, she just didn't make it. But we would say that she is personally wronged, right? But that secret action and many, many secret actions that occur in our society that are discriminatory may go unperceived and may have no significant effect on overall norms and overall outcomes for people of the kind that when I started talking, I said, were the reason why we cared about discrimination as a social practice, right? So we need to explain why that person is suffering a wrong. And that's where the right bits comes in. It's when you talk about someone having a moral right, it's supposed to be the counterpart of that if your right is violated, you suffer a wrong as an individual. It's not just that kind of society is a bit worse off because of it. And that's what matters about it being a right. the question of whether it's a human right is a slightly more complicated one, and maybe we can talk about that sort of a bit later, but that's the core issue. And if you're going to hold that it is any kind of moral right, including a human right, you need to be able to explain that personal sufferance. You also need to explain why suffering this is a distinctive kind of, at least in my view, a distinctive kind of wrong, compared to, say, Vilma's colleagues say, call her Peter. Peter having not got the bonus because her boss was too lazy or incompetent, or because he decided to take a bribe not to give it to her in some kind of corrupt deal at his work. In all those cases, Peter suffers a wrong, but it's not the wrong of discrimination. And we need to know why the wrong of discrimination is a peculiar and particular one that we give a name to, that we legalize as a prohibition, as well as why it's personal.
So some listeners might be listening to this and thinking, well, of course it's a personal wrong as well as a social evil. And of course we have a right against it. But one of the interesting things in your paper is you point out that not everyone thinks this. So some people think, no, we just shouldn't be putting rights against discrimination onto the table. So what's motivating your opponents here?
Yeah, that's a great question. So there are people who try to explain rights, moral rights and human rights, which often they see as the same thing. They try to explain them, or I'm going to use a word here that's going to be quite a meaty word that we might come back to, which is the word grounding. But for now, let's just call it explanation or justification of. Okay, so they try to explain and justify moral rights in terms of harms to people's interests. So they say you have a right because that right creates obligations on others which protect certain interests that you have. Like if you have an interest in not being killed, then you have a moral right against others, which implies obligations on them that they should not kill you. And the reason for that is because that interest is so important for your well-being as a human being. And they try and explain each of the moral rights that we might have that are listed in international conventions, etc., according to that structure, right? You have a really important interest, so important for your well-being, and that explains why you have duties on others which constitute rights towards you. And they have a problem, right? Because they could explain the wrong in discrimination as a practice that is bad for society in these very general terms. And indeed, they accept that. But they can't explain the wrong in discrimination according to individual interests that are of sufficient importance to impose obligations on others. An example of this would be a quite prominent theorist called Alan Buchanan, who wrote a book called The Heart of Human Rights, and it's supposed to be a groundbreaking book because it challenged that certain human rights were genuinely moral individual rights and said, no, these are just kind of legal constructs. There might be good reasons for the construct, but they're not actual moral rights of individuals. And one of the reasons he gives is that there's not enough importance in the suffering of a person in the face of discrimination to justify imposing this kind of range of things that we impose on others that we call anti-discrimination obligations. Right? Not to discriminate against them, to have laws in place that are against discrimination, to prosecute people who do discriminate, etc. All of that's very costly. And if you balance that against a personal interest that might be harmed by discrimination, it's not enough to justify it. So he would say there's no moral right. There might be a general norm that's a good idea not to have discrimination in societies, but he explicitly says in a society where you have a level of gender-based, so discrimination against women or race-based discrimination, so long as that discrimination doesn't attack really important interests that are the foundations of other rights, like your life or your freedom from incarceration or, your access to basic necessities, so long as those things aren't attacked, then discrimination doesn't really touch something of sufficient importance to constitute a right. And so you don't have a moral right to it.
So a couple of questions naturally come up at this point. But pause you there. So one might be that some listeners are listening to that and thinking, well, but clearly discrimination in the aggregate does threaten those very significant and important interests. So does Buchanan and others like him have a way out there? They can say, in aggregate, it's clear that racism contributes to incarceration.
So
and therefore,
that's exactly right. So one way to try and get out of it for Buchanan is to say that a general norm exists that justifies certain rules or principles. In his case, he's focusing on international law, but it could equally apply to domestic law. And that's what he calls an egalitarian status norm. The egalitarian status norm is supposed to be a norm that justifies certain legal principles in place or legal rule on the basis that they have this wide-ranging aggregate effect of making things better, right? So more interest gets satisfied in a system in which there's such a norm than less. And fair enough. I mean, no one's really denying that. That doesn't seem to be like a controversial idea. The problem is that how do you then explain the problem with any one individual suffering an act of discrimination, especially if in some cases more interest seems to get satisfied from allowing, right, that exception. So I give an example in some of my papers of, the discrimination against women in Saudi Arabia that prevents them driving cars. Okay, so I think it's changed recently, and it's now driving a car whilst unaccompanied by a male member of your family is what's forbidden in Saudi Arabia. But whatever the case is, say that you have discriminatory rules in place that prevent you driving cars as an individual woman. If you could show that, more interest, there's social well-being is benefited by that norm, then any one individual woman wouldn't have a case on Buchanan's view. And that seems to go against the notion of these rights being individual moral rights, or rather the problem being that an individual moral line has been transgressed, a personal wrong has taken place against any woman that's prevented from driving. And that personal wrong sounds like and has the shape of an individual corresponding to an individual moral right. Now, he tries to say, well, this big norm that protects sort of well-being in society and it can incorporate these individual protections. But he doesn't seem to be able to explain why it can and does without exception. And if you think there's a wrong in being discriminated against, say, on the basis of being a woman or on the basis of your race, as in Vilma's case, then you're going to want to say that that's wrong in every instance.
It's wrong in every instance, and that each individual can make a claim against
That's right. Exactly.
But others have a duty to answer that.
And that's the problem that the Buchanan view has in just going for the big aggregate explanation doesn't give you that, even though he thinks it does.
And is discrimination distinctive here? Because you might think something like property rights are going to look similar, in that they can only be justified in the aggregate. Each individual, if you steal my laptop, it inconveniences me. Does it affront some fundamental interest of mine? Perhaps not, right? Not clearly, not in this case. What claim then do I have the moral right to make?
That's good. So if Buchanan was brought kicking and screaming to the view that there was an interest-based kind of, whether aggregate or not, but an interest-based kind of justification for having a moral right against discrimination, he might be overcoming at one level, if he could explain it, he might be overcoming the personal wronging aspect of discrimination that suffered, say, in Vilma's case by Vilma. But he still has to do another thing, which is to explain why it's a distinctive wrong, which is what you've effectively asked me, I think, right? So what's missing here is why is there a distinctive wrong to Vilma or to a woman who wants to drive a car in Saudi Arabia from being discriminated against on the basis of being a woman or their race, versus Peter, who is facing a similar outcome in terms of her interests? Like, she too doesn't get the bonus. She too doesn't get advancement, gets to put the fact that she got a bonus on her CV and all the other things around it which make it desirable and satisfying of certain interest to have a bonus. So why in one case is there a distinctive wrong of discrimination, whereas in the other, there's a distinctive wrong, say, of corruption or negligence or something like that? What keeps these two apart? If you're going by interest, it's the same interest. So there doesn't seem to be a way of putting a fine piece of paper between them. They seem to be the same thing, and the explanation can't explain distinctiveness.
Okay, so we've got a sense of the gap, right? The gap is you're saying there's a distinctive personal wrong done to someone who doesn't get the bonus because of their race. Let's hear what your positive account is. So what is the distinctive personal wrong? How are we going to understand what's happening here?
Yes. Okay, so good. That's a big question. And I think one way to start thinking about it is to identify that most of what's been written about both moral rights, individual moral rights, and about discrimination in the existing literature is focused on this explanation according to the importance of some fundamental interests. Right? It's called, some people refer to well-being, others to human flourishing, others to capabilities. But ultimately, what they're getting at is, for a human life to go well, certain fundamental interests have to be satisfied, and we can use that idea to justify why you have a right to something, or to explain why someone discriminating against you is a wrong against you. And as we saw, there's some problems with that. There are some gaps that need filling. But that's pretty much what most people say. There are lots of varieties of that view. Some people talk about, having an interest in being able to make autonomous decisions without having excessive costs imposed on them. So this would be a view like Sophia Moreau's. Or some people talk about equality of opportunity, be it you have an interest in having equality of opportunity, and that's what's attacked by an act of discrimination, like Shlomi Segal argues in an important paper, and a variety of others. I won't go into every nook and corner of the details of that. So my proposal is to move away from that framework, right? It's to try and reconfigure the explanatory framework. So move away from the idea that you explain a right by looking at someone's interest, seeing how important it is, and asking whether that's enough to generate duties on others. But instead to ask about a different kind of normative idea, which is the notion of treatment, how people are treated. You can be treated in different ways as someone who is a bearer of interests, which do not necessarily reduce to the idea that your interests are harmed as a consequence. So an example we could consider would be that there's many examples in the literature and discussions about the possibility of harmless wrongdoing. But we could think about, let's say, a teacher or a lecturer in a department who would normally be on the roster for doing their fair share of the marking, but they're taken off the roster by a head of department because the head of department thinks, in this case, that women shouldn't be doing any marking.
I'd love to have this head of department.
Yes, I'm sure a lot of people would. But does it? Because women are not really the kind of people that should be doing marking, right? According to this head of department. Now, we might say in that instance that the head of department is benefiting the people who don't get to do marking, obviously. So there is a benefit. And their overall interest might not even be dented in any significant way as a result. But there is still a question there about whether this constitutes a significant wrong in treatment of those people as an act of discrimination.
So you're proposing that treatment and what happens to your interests might come apart.
That's it. Come apart, and also it's important to note that treatment helps us to focus in on what's distinctive about discrimination. The reason, at least in normal parlance, that somebody wrongs you when they discriminate against you has something to do that it's because you are a woman, or because you are a Latina, or because you're older, or because you're disabled, or whatever other protected characteristic we might pick on. And because of those reasons, you are treated in a distinctive way. And it may be the case that that distinctive way of treating you doesn't necessarily issue in an overall disbenefit in a particular instance. So like in this case of the marker. But lots of examples are given in the literature where just by sheer incompetence of the discriminator, you don't get a negative impact.
You were saying that even if your overall things are going better, there's something distinctive about being treated in that way. You're saying discrimination is distinctive because of the way it's treating them.
One can say that the distinctive aspect of discrimination isn't the outcomes, what results from it in terms of the effects on your interests. And in fact, that kind of makes sense, because if we think about it, the impact on your interest of an act of discrimination are causal results. Right? There's a causal connection. There's not an inherent either semantic, like a meaning of what you're doing connection, nor is with an impact on your interest, nor is there kind of an unavoidable or absolutely 100% pair by pair or item by item correlation between the two. Things can come apart, as I've just said. So it makes sense to say, well, if the thing that's really distinctive about discrimination is that it's because of your protected characteristics that you're treated in a certain way, how does that fit with the idea that what's wrong about it is to do with something that's a causal result of it? And I give some examples about that. I mean, there are examples where you can be causally affected by an act of discrimination in terms of your interest, but where you're not the target of the discrimination, and we wouldn't say that you were wronged by it. So you can imagine a case where getting the bonus for Vilma and the status that comes with it will benefit her team, which contains other Latina women, say. But because she doesn't get the bonus, those women don't benefit, and their interests are negatively impacted by a wrongful act. But they're not discriminated against. Vilma is. So there's a causal connection, but not an inherent connection to the act. Again, that indicates there's something specific about the actual way I'll say that again. Again, that indicates that there's something specific about the content of the act that makes it wrongful. And my proposal is that what makes an act of discrimination wrongful, and to summarize a very long discussion, is that it treats the interests of a person less than equally, or gives them less than equal consideration or weight because of a protected characteristic like race or gender or sex or age, etc. In the paper, I talk about group identities to try and explain which one of these kind of features of humans are the ones that we must take on board in this discussion. But that is a different type of explanation. As you can see, it doesn't, it may result in some cases that it may be the causal result that you don't suffer in terms of your interest in any significant way, but you still face an act of wrongful discrimination because you have been treated in a way that's not in line with the kind of creature that you are. And this is what we call a status-based rather than an interest-based explanation.
So it's a prelude to give equal consideration of your interests on the grounds as your group characteristic. So on your account, is this going to include not only the things we usually think of when we're thinking about discrimination? So the woman doesn't get the job, the person of colour doesn't get the raise, and so on. Is it also going to include cases where a man gets put further down the interview list because they're trying to recruit a more diverse workplace, all those kinds of positive discrimination cases, right? Where we try and make the world better through ensuring that women can be hired or ensuring that our workplace is more diverse?
Yes, that's a great question. I have continuously been using discrimination and wrongful discrimination interchangeably in what we've been saying. I should clarify that. Now, some people might call positive discrimination discrimination or affirmative action discrimination, but it's an open question because it's an open question whether it's wrongful. Now, what's good in this view, from my perspective as the originator of it, is that we can explain those cases as non-wrongful examples of differential treatment, not discrimination really. And that's because when we say not give marking to a member of staff in a department because that member of staff say, as a woman, has taken on so many roles in the past, or has had those roles imposed on her as a consequence of her sex or gender, then we are rectifying the way that her interests have been treated. And rectifying that is supposed to take into account people's interests in an equal way, in no less than equal way, right? So that's the idea behind affirmative action. It's not to make women better off than men, how it's represented by people who are opponents of it. It's to rectify a problem in terms of how they have been treated in the past or are being treated right now, and to bring things to kind of an equal level and give their interests the equal concern that they should have.
Does this work for more group cases? Let me explain what I mean. So I can see how your line of reasoning with your equal considerations and your interest in making sure that we're tracking what's gone wrong for the particular agent. I can see how this works for you on marking. Okay. So we're just correcting a previous inequality this person has faced and so demonstrating our equal consideration of her particular interests. It's the right kind of treatment. Does this line of reasoning work where what we're trying to do is remedy a broader social ill that may or may not have affected the circumstances and chances and consideration of the interests of the person in front of you? So here you are in the interview case again, and you're deciding whether to engage in affirmative action or positive discrimination to ensure a more diverse workplace. Is it going to work there, your line of reasoning? Because it sounds like it wouldn't. It sounds like it wouldn't because I'm not equalising the consideration of your particular interests here. I'm equalising for the group. Or do you think it still works?
Okay, so that's again an amazing question. So we have different terminology for those kind of cases and those kind of questions, at least in the legal context. So we often talk about things like indirect discrimination. There are questions about whether indirect discrimination is more about social engineering in order to rectify sort of society-wide problems versus individual cases where we use the terminology of direct discrimination. So my position or the paper is fundamentally trying to explain the latter, which is direct discrimination. Why, if it is wrong that an individual is treated in a discriminatory way, why is that wrong? And why is it wrong in a way that is personal, right? That it's a wrong to them, and distinctive in a way that other kinds of wrongs to them are not that kind of wrong. It's different from those other kinds of wrongs, even though there are other kinds of wrongs. It wasn't setting out to explain sort of the society, what we should do society-wide or what we shouldn't do, but it's compatible with a view where we would say that we want to improve sort of social well-being, right? I'm not kind of ruling out considerations of well-being ultimately. I'm just saying that when it comes to individual direct discrimination, we need a different kind of explanation.
So I take that, but I guess my question is something like, could the man who's not shortlisted make a claim on your kind of model to not having had his interests equally considered by virtue of not being shortlisted on the grounds that he's a man?
Only if the grounds for him not being shortlisted are not to do with a calculation about improving benefits overall. Okay, or improving benefits in a calculation where everyone is taken equally into account, right? So imagine that the calculation was like, shall we have some affirmative action projects? Yes. Okay. Let's work out what kind of affirmative action project is. I propose that we have an affirmative action project that does not take into account the interests of men in any way, right? And men's interests are nullified in that consideration. Everybody else's interests are included. And that's not because of historical injustice. No, we're just going to exclude them. In that case, you've done what I call discrimination, and they would have a claim, right? But if the reason you've done it is because you're trying to take everyone's interests into account in an equal way, and the consequence of that is this affirmative action, then that's not really an act of wrongful discrimination, and it wouldn't fall foul of my view anyway.
Great. So we've got now, I think, on the table a different grounding or a justification or explanation of how to get a right against discrimination to the table. This is let's think about the treatment, not just about the interests affected. Let's talk about the next step that some people might think is going on here. So that looks like you've got a moral right. and you've got a justification for this moral right. Your paper's about human rights. So are human rights different to moral rights? Not all rights, I assume, generate human rights. Is there something special and different about human rights? And I guess the next question is, and is there some reason to stop short of saying there's a human right against discrimination, even if we're all now on board that there's a moral right against it?
Yes. So here we get into some quite subtle if we haven't already, this is some quite subtle and swampy ground. So I should declare that some people think that if you can show that something is a moral right, then that's sufficient to show that it's a human right. There's that view exists, and it's very difficult to find people that challenge that in a consistent way, although some people do challenge it. Some people make a distinction between human rights and moral rights on grounds that are contentious and that I wouldn't agree with. So an example would be someone like Josh Cohen or David Miller, who think that human rights are all about, at least at some level, they're about international acceptability of a set of rights, rather than what we would, thinking in our pure ivory towers, think were the moral rights that everyone had. So take the moral rights that we think everyone has, they think maybe a subset of that is what constitutes human rights, and that's because those are what would get accepted at an international level, and that's what they associate with human rights. Or they might add some other kind of qualifier, like only that subset deals with fundamental human needs or something like that, in order to sort of pare down and cut down the list. Often this is motivated by a rejection of the idea that liberalism, which they associate with the full gamut of human rights, liberalism is a requirement on all societies. They say if we're going to be much more pluralist about that, then we're going to have a smaller list. I don't think that any of those arguments really rule out a human right against discrimination. They might rule out some forms of discrimination as being covered by that human right, but they don't explain why discrimination as such is ruled out. They'd have to have an account of some kind of basic set of rights or some reason to have basic rights that protected individuals that was acceptable to us as part of that offer for the international agreement. And we'd have to explain why discrimination didn't make that cut. And that would require a theory rather than just a general reflection on what people might agree or not agree. And
great. I think on your view, if we've got a universal moral rights, it's something that we all have by virtue of being humans, that we have our human right. We're not here talking about the kind of moral rights that I'm at. You promised to me that you'll buy coffee, and you don't. You might think I had a right to the coffee and you owe me something.
So that's another way of trying to do it. Some theorists try to say what would be the most universal kind of rights that we can make sense of, or the historical or classical way of doing this comes from H.L.A. Hart, who makes a distinction between what we could call what he calls general rights, which are rights that you have just by virtue of being human, regardless of any special relationships or any special circumstance or location, etc. So it's not the rights that you'd have because you were a family member against your spouse or against your parents as a child. It's not the rights that you'd have because you'd signed a contract. It's not the rights that you have as a member of a society, as a citizen. All those are special rights. The only ones that really would make it in the cut as these human rights would be the super universal general ones that you have, whatever. Okay, and a lot of people have that view as well. I don't have that view. But even if you do have that view, it seems that at least some aspects of discrimination are going to make the cut as requiring of universal attention. To use an example, maybe Vilma's case isn't a case of a human right. It is a case of a moral right because it relies upon an employment relationship to arise. Right? So employers shouldn't discriminate against you in terms of their bonus schemes. So it's very special in that sense. So it may be a moral right, but not quite that universal right if you hold that view. However, we can think of cases of discrimination that don't rely on these special or non-general relationships. So distributing aid to a population or who gets to cross a border or move freely, if you do that on the basis of race or ethnicity or on the basis of gender or on the basis of sexuality, it still seems to be a wrongful discriminatory act and not one that depends on any kind of special relationship. So that, again, doesn't help us to get rid of discrimination from the human rights sphere. If you want my personal view, I think that once we leave behind the idea that the way to justify human rights is in terms of the promotion of people's interests, then there shouldn't be a problem in thinking about different rights, moral rights, serving different purposes. We can say, for example, that the respondent being a state makes a significant difference because of the kind of things that states can do. Right? States can treat you in ways that individuals can't treat you. They can establish whether you're subject to the law or not subject to the law. They can impose obligations on their members to treat you in certain ways. And all of that means that we ought to have a special category of obligations on states and a special category of accountability for states that wouldn't be captured necessarily by the category of accountability we apply to individuals. If an individual murders someone, we can hold them accountable in terms of criminal liability. Depending on your favorite view about what should follow, it's kind of either reform or punishment or something else. But they're individually accountable, and we stigmatize that individual act, and we stigmatize the character of people who carry out those acts as murderers. But that's not how it works for the state. If a state orders its officers to carry out an extrajudicial killing, say, they don't face those kind of corrections. We don't put a state in prison. We don't consider reforming a state, at least in terms of like re-educating a state in terms of its character or any of those things. What we think about is how we can change the order of that state, meaning the laws usually of that state, in such a way that those obligations to carry out those kind of acts that it imposed on its officers can't be imposed in future. And I think we have different terminology for standards that we apply to states like that and standards we apply to individuals.
So is your thought here that your account of human rights, so it's got a couple of advantages I think we've got pushing for us. So we've got one advantage is it's going to make sense of the fact that discrimination is a personal and distinctive wrong done to an individual and that they have a claim against it. And are you saying that the other is it's going to do a much better job, your account, of being able to make sense of the differences between states doing murders and human people doing murders one-on-one? And is your thought that the fundamental interest story can't do that for us in the same way?
I think it opens a space, yes. So it opens a space for the possibility of having different moral names for different moral standards according to the kind of agent that performs them because of the powers of that agent, which if you're an interest-focused person or a well-being focused person, it's not going to really make much sense because it doesn't.
What matters is whether the interests are affected. Something like treatment and what treatment means is very importantly different with the role that we're playing. So if you're a state, Exactly. It means one thing. As a teacher, I have to not discriminate in a way that in my personal life is not as relevant a consideration. Is that the kind of thing you're trying to track?
Yes, that's perfectly put. That's exactly it. So, yes.
Whereas if it was just fundamental interest, it would apply equally, right? Whether I'm a state or a teacher or just someone in my own personal life, same.
We can talk about if the interest-based approach flattens out the notion of responsibility. It just kind of makes it uniform. It's all that matters is what is produced, right? And it doesn't matter who produces it or what powers they have, etc. If a state kills you extrajudicially or an individual kills you, the same wrong and consequently the same right. Right? There's no special name that we give to either one of those because all that matters is the interest that's affected. Whereas, on my view, hopefully there's a space for making that distinction.
So it's a transformative account that you're offering us. It's not just, it turns out, a paper about discrimination. It's also a paper about how to do human rights better and the differences it might make, which role we're playing as to what we owe. So thank you very much, Saladin, for that excellent and deep dive into what's going on in human rights, how to do them better, how to ground them better, what it might mean for thinking through the different kinds of rights we have against certain types of organizations as compared to others. So today we've been looking at Saladin's chapter, Is There a Human Right Against Discrimination?, which is forthcoming in the Routledge Handbook on the Philosophy of Human Rights. As ever, these details are in the show notes for this episode. Remember to make sure you don't miss out on that or other future episodes of UCL Uncovering Politics. All you need to do is subscribe. You can do so on Apple, Google Podcasts, or whatever podcast provider you use. And while you're there, we'd love it if you could take a moment of time to rate or review us too. I'm Emily McTernan. This episode was produced by Eleanor Kingwell-Banham. Our theme music is written and performed by John Mann. This has been UCL Uncovering Politics. Thank you for listening.